What types of damages can you claim for breach of contract? Imagine signing a contract and then the other person or company doesn't do what they promised. What can you do to fix that? Well, in business law, there are several ways to get compensated when someone breaches a contract. Let's walk through the main types of damages you might claim. First up are compensatory damages. These are the most common and are meant to cover what you actually lost because of the breach. They are split into two parts. The first is general damages, which cover direct losses. For example, if a supplier doesn't deliver goods on time, you might have to buy similar items at a higher price. The damages would cover that extra cost, any prepaid amounts, and expenses like returning unused goods. The second part is special or consequential damages. These are for losses that aren't immediate but happen because of the breach. For instance, if a delay causes you to lose a big client or profit, you can claim those lost profits if they were predictable when you made the contract. But these damages must be foreseeable at the time the contract was signed. Next are liquidated damages. These are damages agreed upon beforehand in the contract. If the contract says a party must pay a fixed amount if they breach, and that amount is reasonable, the court will usually enforce it. For example, a contract might say if a builder doesn't finish a project on time, they owe a set amount per day of delay. Then there are nominal damages. These are small amounts awarded when a breach happens but no real financial loss occurs. They are symbolic, like $1, to show that a breach took place and to protect your rights. Punitive damages are less common in breach of contract cases. Usually, they are not awarded because the law focuses on compensation. But if the breach involves fraud or serious misconduct, courts might award punitive damages to punish the wrongdoer and discourage similar behavior. Sometimes, monetary damages aren't enough. Courts can order equitable remedies like specific performance or injunctions. Specific performance requires the breaching party to do what they promised, often used for unique items like property or rare goods. Injunctions prevent someone from doing something that would breach the contract. Rescission is another option. It cancels the contract entirely, releasing both sides from their obligations and putting them back to where they were before signing. In business, understanding these damages helps decide how to handle a breach. It also guides how contracts are written, especially with clauses that specify damages like liquidated damages. Knowing your options can help you decide whether to settle or pursue legal action based on what you might recover.